Yes, Shivpriya. Introduce yourself.
My name is Shivpriya. I'm from Bihar, and I have done my graduation from in BCom and LLB from Banasali Vidya, completed in year 2009. And I do have involved myself as an advocate at Patna High Court, but not started the practice yet.
Okay.
And since my graduation, I am into the preparation of judicial services.
Okay. Anything else you want to let me know? What are your hobbies?
Reading and traveling.
Where you have traveled recently?
Recently, ma'am, I've been to Missouri in month of May. Yes,
Okay. How was the aura there?
it was nice.
It was nice. Okay. Why you want to become a judge?
Since having law as a career, I do have a lot of options, but I think why not? Why not? I decided to choose judiciary as my career option when I was doing internship at the court,
Hmm.
and since I have a lot of options, I decided to pursue judiciary because judiciary it is one of the considered as one of the principal organ of government, and it is entrusted with the responsibility to uphold rights and liberties of people, as well as by this way I can also contribute to the society,
Okay.
being part of the system.
How your education, the past education which you have completed from Vanasthali, how will it help you in making a better decision or anything like that?
Having completed my education in Banasali taught me a lot of things. Firstly, uh, a good management and how to survive in very difficult situations, as well as I was good in academics. I secured third rank in my college.
Okay, fine. Uh, what is your view regarding a court? Regarding a court in a society?
Court, ma'am.
हाँ, कोर्ट रिगार्डिंग अ कोर्ट न्यायालय का क्या रोल रहता है सोसाइटी में?
Court is in trust. It is one of the order of the government. It is a very important role, as it is entrusted to safeguard the law and uphold the rights of the people. So it plays prima facie role and very important role in the society, because it is considered uh, as a guardian of fundamental rights or caretaker of rights of the people. The society has a very much trust in court, the judicial system.
What is the difference between bar and bench?
Uh, a bar refers to the association of advocate, whereas bench refers to the where judges sits.
Okay, good. What is the power of judicial magistrate?
Under CRPC.
Under CRPC, right?
Uh, Judicial magistrate is empowered to give a punishment of term imprisonment not exceeding 3 years and fine of 10,000, and it has power to take cognizance over the cases, and any cases complaint can file to judicial magistrate in respect of commission of any offence, be it cognizable or non-cognizable. And the judicial magistrate also empowered to record the statements and confession under section 164 of CRPC.
Okay, fine. What is the difference between judge and a judicial magistrate?
The judge is a person who is looking or who is administrating the civil cases. Civil judge is usually referred as a judge, and magistrate is a judge when he is looking into the criminal cases or criminal matters.
Are you sure this is the only difference between them?
There can be more, but I'm not
Are you
able to
having
recall.
Are you having a notepad with you? Just write down this question because it is not clear to you. Okay. Fine. Okay. Recently, contempt of court was very much in limelight. Just go through some of the views, share some of the views of yours on contempt of court.
Contempt of court implies this contempt can be in form of civil contempt or criminal contempt when anyone is disobeying the order or judgment of the court. It amounts to civil contempt, whereas anyone is injuring the process of court or abusing the process of court, then it amounts to criminal contempt. It is Supreme Court and High Court has the power itself given under Constitution to punish for contempt, as well as there is a different statute, that is Contempt of Court Act 1971, to punish for contempt.
Okay. What was the case? Recent case which was on the limelight for contempt?
One I can recall is Indre Prasad Bhushan case.
Yes. Right. Okay. Fine. Explain section 299 of CRPC.
299 of CRPC. It is this section states that when the evidence can be taken in the absence of accused, when accused's absence or his identity can, if any offence is committed by a known person, or in case of interest of justice, then in such circumstances, evidence can be taken in the absence of.
Which section is related with section 299 of Evidence Act?
273, Evidence Act.
If we relate the sections of CRPC 299 with which section of Evidence Act, you will relate it?
Section 32.
It's 33.
32.
32 is dying declaration. Okay. चलिए next question पे आते हैं. What if the accused while on bail, the accused in on bail does not appear on a particular date?
Then his bail can be cancelled by the court because while granting a bail, a person is bound to for his security and bound to appear in the court of law at the specified date. So
then court will be opting which sections? Which procedure will be opted by the court if the accused is not appearing on that specific date?
Warrant can be issued. Warrant of arrest can be issued.
Okay, fine. And इसके साथ साथ आपका it will be contemplated with section 446 in which there is a procedure when bond has been forfeited. Okay. चलिए. Next question is that कि bail is a form of detention. Yes or no?
Can you repeat the question?
Is bail is a form of detention? Correct or incorrect?
Detention. I think it is incorrect because bail is a kind of right or matter of right or privilege where one person has a right to be released from detention on furnishing security or subject to the other conditions.
So that means you are saying that bail is a liberty.
Sort of, yes, ma'am. It is fulfilling the conditions required by law. Person can get released or it is a form of liberty.
So why the conditions which has been infringed by the accused is again it is like again he is detained? Why is that if he is on liberty?
Because bail is not absolute right. It depends upon the nature of offence and it depends upon if it is cognizable offence, then bail can be granted as a matter of right. But in case it is a mandatory bail, but in non-cognizable offence, it is totally upon the discretion of court.
Bail, which provision relates to bail? Can you recall the provision?
Chapter 33 of CRPC from section 436 to 436 onward.
Okay, fine. What is the meaning of bail?
Bail means bail is to release. It is a order of court or order which secure the release of person from arrest and detention.
But this much only. There is some
Uh,
bond, there is sureties.
yes, ma'am. On furnishing security or signing bond.
Okay. See, this question is very much important regarding bail. The thing is that the question is bail is a form of detention or not. So it is a form of detention. It is not a liberty, not absolute, not anything like that. It is not a liberty. Okay? Because if we say about arrest is what? It is a lawful custody. Okay? It may be a judicial custody, it may be a police custody, right? And when we talk about bail, there is a shifting. There is a shifting. This means that the accused is now on whose custody? It is on the custody of the sureties. Getting my point? Okay, so it is not a absolute liberty. It is not any form of liberty. Okay. So basically, his legal custody is transferred to the custody of sureties. Okay, fine. Let's go on the. What are your optional subjects?
Constitution and administrative law, Hindu law and Muslim law, and third was contract and law.
Which is your favorite subject in these optional subjects?
Constitution.
Constitution is your favorite subject. Okay, fine. Why Constitution is known as the living law?
Because there is a provision of amendment where we can bring changes to the constitution as per the requirements of the society. So therefore it is referred as
Which provision is related to the amendment?
Article 368 of Constitution.
Okay, fine. Is there any guidelines relating to the appointment of judges? In which case it was said regarding the appointment of judges?
There is a collegium system which was laid down in all three judges' case.
Which case? Name of the case?
There was a third judge, there was first judge's case, S.C. Gupta versus Union of India. It was case of 1981 of Supreme Court, and the second was Supreme Court Advocate on Record Association case.
Supreme Court Advocate of Records versus Union of India. Okay. Who was the judges in that? Who was the bench comprises of?
In first judge's case, it was bench. It was compromising. The chief justice was the main judge was Justice P.N. Bhagwati. I am not able to recall the whole bench name.
Fine. Not an issue. Okay. What is a fundamental right?
Fundamental rights are the basic human rights which are guaranteed to a citizens of India under Part 3 of the Constitution against the state action.
Are these rights equally given to every human in India?
No, there is a categories which there are certain fundamental rights which are only applicable to Indian citizens.
I am asking only for the Indian citizen only. Are these all fundamental rights are given to all of the Indians?
Yes, ma'am.
Sure. There is a recent case where a community of peoples are not given their fundamental rights also.
Right.
Go through that. That is related to the prostitution and the
Buddha's case where Supreme Court upheld the right of sex workers.
yes, in that only. The persons who are in the sex worker, they are the sex worker and they are not given a right for residence. They don't have the address for the residence, and this come into limelight due to COVID. Okay, so this is very important. And the cases which are due to the COVID-19, go through that cases also. Okay. And pardoning power of governor.
Ma'am, pardoning power, government is given he has a power under Article 172 of Indian Constitution, where he has a power to grant pardon of commute sentences and power of deprive remit sentences in any offence which is committed under the state law, which is under the state law.
Okay. How many languages are there in Constitution?
Currently, there are 22 official languages.
In which schedule it is given?
8th schedule.
In 8th schedule, okay. And what is concurrent list?
Concurrent list is a list on in which the subject on which the subject of concurrent list, both parliament and state legislature can enact a law.
Okay. If there is any conflict between the state and the central government regarding the formation of law, so which will prevail?
The law of parliament will prevail.
Okay, fine. Let's go with something regarding Bihar. I will be not asking very much questions from Bihar because in the next interview we will be focusing only on the general studies. Okay. Who is the Chief Justice of Patna?
Sanjay, Chief Justice of Patna, Sanjay.
Okay. Honorable. Okay.
Honorable.
Fine. How many courts are there in Bihar?
How many courts? There are high courts.
Every high court is only one. District court and subdivisional courts.
There is a 38. I have no idea what court to do.
37 district courts are there and 42 divisional courts are there. Okay, write down it. Okay, first female judge of Bihar, Patna.
Gyan Sudha Misra. Honorable Gyan Sudha Misra was first female.
Justice Indu Prabha Singh. Okay. Who is the Advocate General in Bihar?
Lalit Kishore.
Okay.
You have to mention as a question honorable before.
Yes, you have to give respect. Okay.
To every other designated person, like
obviously you have to give this thing. Na? It's very important. CGI, who is the Chief Justice of India?
Currently, the CGI is Honorable N.V. Ramana, but he is going to retire on 22nd August.
27th, correct. Okay, and who will be the upcoming judge and which number is that?
The 49th CGI will be Honorable Justice D.U. Lalit.
Correct. Fine. What is rejection of plaint?
The rejection of plaint is given under Order 7, Rule 11. The grounds are when the plaint does not constitute cause of action, or the relief is undervalued, or the plaint is insufficiently understamped, insufficiently stamped, or the plaint is time barred, or it is and lastly, if it is not complying it is not filing duplicate, or it is not complying the Order 7 Rule 9. Then
and what is the difference between return of plaint and rejection of plaint?
In return of plaint, the plaint is returned for the presentation in proper court due to lack of jurisdiction, whereas plaint is rejected due to non-compliance of certain provisions provided by the.
Okay. What is the application for setting aside ex parte decree? Where it is given? Application for setting aside ex parte decree.
Order 9 Rule 13 of CPT provides for setting aside the ex parte decree, whenever any decree is passed, ex parte, that is, in case called for hearing, only plaintiff appears and defendant does not appears. Yeah, even after providing a service of summon, then decree is passed ex parte, and defendant can file application to set aside on grounds that the service has someone has not, the service of someone has not given and has not done, or other showing other sufficient causes.
Fine. What happens when defendant does not appear, does not file an written statement?
He is bound to file written statement within if the summon has not been served, if someone has duly been served to defendant, as then he is not filing the written statement, then the court will pass expiry decree.
Is there any time limit in which he have to file the written statement?
Yes, ma'am. It is within 30 days of service of someone. It can be further extended to 90 days if defendant shows sufficient cause to the court.
Okay, grace period is 90 days, summoning service of summon is 30 days. That means 120 days he is having to submit his or her written statement. Fine. Hindu law is also there, na? Hindu and Muslim law. What are the sources of Hindu law?
The sources of Hindu law can be categorized as ancient sources as well as modern sources. In ancient sources, it is Shruti, Smriti, tradition, commentaries or custom, whereas modern sources of law consist legislation, precedent, and doctrine of equity, justice, and those kind of that.
Fine. What are the grounds for divorce in Hindu Marriage Act?
Section 13 of Hindu Marriage Act provides for the divorce, and the first section 13 subclause 1 provides a ground for divorce for both husband and wife. They are adultery, cruelty, or if husband has renounced the world for religious order, or he is not heard alive for 7 years, or if he has converted to any other religion, or either he is suffering from any venereal diseases. There is one more ground given under section 13(1)(a), which states that if the decree of judicial separation or decree of restitution of conjugal right has been filed and there is no cohabitation between the parties for more than 1 year after the passing of the decree, then also both husband or wife and either of the party can avail the ground, avail the divorce on this ground.
What are the grounds regarding the maintenance awarding for the divorce? On which grounds, if you are the judge and you are awarding a maintenance to a person or a plaintiff, so what grounds you will be going through?
The parties, the marital status of party, if he is married or unmarried.
No. I am asking about the divorce, na? So he or she is married. Okay, I am asking ki what will if you are deciding a maintenance, so what grounds you will be going through? How will you decide a maintenance?
I will consider several factors like the lifestyle of what are the basic necessities of the party who applicant, and
for a wife, how will you decide? Being very much particular, for a wife, how will you decide a maintenance?
What are her basic necessities of life, and how many children are there, and is she has any source of other income or not.
केवल वाइफ का ही देखना है ना कि मतलब she is very much suffered. You have to go through with the husband side also. You have to consider both of the family financial status, education of the wife also. In which recent case this has been given, this guidelines has been given? Okay. The case is Rajneesh versus Neha. Okay. And the bench was of Indu Malhotra, Honorable Justice Indu Malhotra का judgment था. And it is very important whenever it is regarding the divorce maintenance. Okay. for deciding the maintenance, you have to go through that. Okay. Name any 4 codified Hindu law.
Hindu Marriage Act of 1955, Hindu Adoption and Maintenance Act of 1956, Hindu Minority and Guardianship Act of 1956, Hindu Succession Act 1956.
Okay. Fine. What are the grounds of divorce in Muslim law?
In Muslim law, there are 6 grounds. Firstly, there is express mode, which includes talake, biddat and talake siddat, which is further categorized into talake hasan or talake hasan. It is in express mode. The husband can divorce wife, give talaq to wife by pronouncing in successive terms, successive period.
But this has been now banded, no? It has been what we say.
Talaq biddat, triple talaq.
Triple talaq has been forfeited by
Yeah.
the court.
Yes.
What's your view regarding that? It is correct or not?
It is correct, and it was much waiting. Justice was then very delayed in this case because it was very an arbitrary law against the women. Because on arbitrary law, it was violating Article 14 and it was against the dignity of women, because men has an absolute kind of right and to give divorce, and there was no period of revocation in this kind of.
What is your view regarding hijab ban judgment?
Currently, hijab is declared as it is not essential religious practice under Article 24 by Constitution by Karnataka High Court. I agree with this case.
Okay, fine. Is wearing hijab?
What kind of view should I take? What should I say? I very much confused. I don't know what to say.
We will come this on the end. Na? We will discuss this in the end. Okay. Is wearing hijab is protected by the right to freedom to consign?
Wearing hijab is a personal choice, or is a personal right of a person.
Which case you relate with this hijab? If we talk about only for Article 25, right to freedom of consign, which case you relate with this?
Freedom of consign.
Bijoy Enamul case? Remember?
This is national anthem.
National anthem case. So it is little bit similar. Okay, the facts are little bit similar regarding that. Okay, fine. What was the bench comprised of regarding hijab ban judgment?
It is 3 judges bench. I forgot the name of the.
Okay, just write down. It is Chief Justice Rituraj Avasthi, Justice Krishna Dikshit, and Justice J.M. Kazi. Okay. What are the sources of Muslim law?
Sources of Muslim law can also categorize as the primary sources and secondary sources. The primary sources are Quran, then Sunnah, and Ijma and Qiyas. And secondary sources include customs and legislation.
What are the essentials of a valid custom to become a law?
Custom, to be a custom, if it is a law, it must be observed for a long period time immemorial, and secondly, it should be definite and certain and definite, and it should be uniform, and it should be accepted by a large number of society, and it should be reasonable and not opposed to the public policy of the people.
Oh, fine. Who had observed that Muslim marriage is both civil contract and a religious sacrament?
Muslim marriage is both sacrament and
Yes. Okay. It was the case Anis Begum versus Muhammad, and the judge was Sahab Suleiman, Sir Sahab Suleiman. Okay, 1933 का case है ये, in which he observed that it is Muslim marriage is not only a civil contract, it is a sacrament also. Valid marriage of Hindu law, Muslim law. How will you validate the marriage of Muslim law? What are the essentials?
Firstly, parties are under capacity that parties must be Muslim and attain the puberty age and sound mind. Secondly, there must be offer and acceptance. And thirdly, in case of Sunni, there must be presence of at least 2 witnesses. And there must be lastly nikah nama, which contains the terms and conditions of marriage, details about dower and
in case of second marriage in Hindu, in case of second marriage, how will you decide regarding the surname? Who is having the power to give the surname?
Recently, there was a case of Supreme Court where it was held that if the first husband has been died, then naturally mother is a natural guardian. And if she marries for the second time, then she is also being a natural guardian, she has a right to give a surname of the second father.
Huh?
Sorry. Yes, second father. The small father, sorry. The same father.
Who is having a choice regarding that?
Mother.
Mother is having it. Okay, fine. Good. In which case the rights Muslim Women Protection of Right on Divorce Act, which case gave birth this act?
Muhammad Ahmad Khan versus Sahabano case of 1983. In this case, it was held that the Muslim male has a duty to provide maintenance to Muslim women, divorced women, even beyond the iddah period.
What is the meaning of Musha?
Right of preemption is death. Musha. Musa is a deathbed gift is referred as.
Go through it. वक्फ क्या होता है? What is the meaning of वक्फ?
Waqf is a trust under Muslim law. When any immovable property is dedicated to God for religious and charitable purpose, it is known as waqf.
Manager of वक्फ
is known as mutawali.
Okay, correct. Fine. Acha. What do you think? How was the interview?
It was good. I need to go to recent cases and few topics and go through.
Right now I have not asked any question from the evidence. That will be the part of the second interview, and the general studies will also the part of the second interview. Okay. Presentation is good. You are confident enough. Okay. And if you are not very much clear about anything, to just say कि sir I don't know or ma'am I don't know. Okay. Baki you have attempted all the questions very good. What you will be wearing in the interview?
I'm confused between sari and kurti and pant, white kurti and pant. मैंने option में रखा है because sari is I'm not that
you are not comfortable. You will be always be there ना कि ये संभालना है वो संभालना है. Okay. Just wear a simple suit. Complete suit, not only a kurti and pants. Just go with a proper suit with a dupatta and everything. Okay.
No, dupatta is मतलब important है. Dupatta नहीं हो तो चलेगा.
नहीं. See, when it is like when we talk about the fashion sense, it is okay. We are going like only with only with the kurti and the pants. But when you are in a formal way, so it comprises all the three parts of a salwar kameez. Okay, because they are very much elder from you, and it will make some negative thing, which is not good. Okay, opt a particular formal suit. Okay, formal light color suit, you should wear it. Okay, fine. Anything else you want to know?
Just one more thing na juda banana.
See,
Yes,
hairstyle is like in which way you are comfortable. Don't do go like too much of doing anything with the hair. Just a simple ponytail should be very much simple. Don't wear a very colorful lipsticks or anything. It should be very simple, very basic. Okay. Is there any kind of tattoo or there is anything which is visible? Okay. Huh. Because it should not be visible to the authority. That's the thing. Anything else? You are asking regarding your opinion. ठीक है. See, in opinion point of thing, you should start with your opinion, positive or negative, whatever you think. ठीक है. But in the ending of your answer, it should be diplomatic. Don't go straight forward. Getting my point?
diplomatic in the sense, I should not go against. Like, it should not
See,
be
when it's about hijab, ठीक है, when it's about the hijab, maybe the interviewers may comprise some of that religion also, Muslim religion also, so that will hurt his or her feeling also, na? So just start with your whatever you think. Don't be so much straight. Yes, I support this thing. Don't be like feminist. Don't go in that portion. Yes, if you do that, if you want to say yes, to be very much polite. Okay, and by closing your answer, so just they say your things like it's up to the religion, it's up to the girl who are opting hijab. Right now also many of the girls are opting, so they are about their consent. If they want to do, they can do that. Okay, so it's like that. It should be opening with should be like your view, and by the ending of your answer, it should be very much diplomatic. It should not be very much straight, and it should be very much polite. Whenever it is regarding the religion, it should be very much polite. Okay. Anything else?